Conveyancing inquiries, then, the latest update. Raising relevant preliminary inquiries is, of course, a vital part of the conveyancing process. Your buyer client is not yet committed to buy, and what you find out may be crucial to their decision to proceed. Your seller client, on the other hand, needs to know the importance of providing meaningful and not misleading answers. Asking the right questions is one thing, what to do with the replies is quite another. Now, all of this is set against the background of ever-increasing burdens of investigation, both for your client and their mortgagee, which once meant simply approving the title, is it good and marketable, but which has now widened to far wider subjects such as the condition of the property and even identity. Make the wrong call, whether acting for a seller or a buyer, and the risks are immense, going to the heart of the contract, involving issues sometimes of fraud, and in the end, your professional obligations. So let's look at some of the bullet points that we're going to go through today. We'll include misrepresentation and the importance of sellers answering preliminary inquiries fully, example Wilson and Sharp Investments, and Falmouth Property Investments, and developer disputes. Not only buyer beware, but also seller beware, the risk of fraudulent misrepresentation. We'll look briefly at the Misrepresentation Act, 1967, remedies, rescission, damages, Law Society Management Inquiry Form, some specific questions ranging from solar panels to septic tanks, Japanese knotweed to double glazing, and look at standard forms of inquiries. What about the liability of the surveyor involved under conveyancer? What about cladding questions involved in the property information forms? TA13, the Law Society Code for Completion by Post, and additional questions that may therefore, as a result, need to be raised. When you come to new build and off-plan purchases, in HBC, there's a lot more questions involved there. Where there's an indemnity policy, do you take it or leave it? Or do you raise more questions? What are non-reliance clauses? Are there attempts at exclusion of liability? The standard conditions of sale, 5th edition, the protocol, and the danger of relying on the phrase, not so far as the seller is aware. There are questions of insolvency, of indemnity insurance, identity and fraud. As often the case, we'll look at the appeal decision in Dreamvar and Mishcon de Rea. There are inquiries to raise with your own client and with the lender. Does the client own another dwelling? Are they really first-time buyers? Have they been involved in a dispute or a complaint? Questions arising out of additional reports or surveys. What to ask the lender, the case of Miss Steele and NRAM Limited in the Supreme Court is a good example of that, which we'll look at in detail, and new build disclosure forms. And finally, your obligation to warn your client as to the effectiveness of your advice and the scope of your retainer.